Hello, this is Brian King, and welcome to Civil Litigation Top Gun School. We want you to be the best litigator in the Carolinas when you're here at King Law. And when it comes down to who are the best litigators, you're talking about civil litigation. It's intense. There's a lot of motions practice. There's a lot of things that goes on. So we're going to jump right into this, and we're going to go through each step until you become the civil litigator that you want to be. So as we start this, I want to start by talking about what we do at King Law. And when we're civil litigators, a lot of times what we're trying to do is take any kind of case that involves the amount of money, a contract, maybe a house, maybe real estate, maybe it's an estate litigation. There's a lot of different ways that you can get yourself into a civil litigation matter. Bottom line is it's going to be a lot of documentation, a lot of information that you're going to want to get a hold of. So let's talk through that. For King Law University, we go through a lot of the different issues, taking you from the beginning of the client journey all the way through the entirety of the process. So here we are in 2022, and what we're trying to do from the very beginning is to market. And building the market is about talking to other attorneys, talking to other people in the area, talking to past clients of ours, business owners. These people are going to have litigation issues, and that's where we want to be able to step up and be a part of it. The most important thing about civil litigation is that first phone call. Generally speaking, it's a business owner, or maybe it's an individual who has an easement or right-of-way issue or something like that, and they have to make a decision that no longer can I handle this myself. I need to get someone else involved. So knowing that, it's important for us to be available at that very first phone call. We pride ourselves in compassion. First thing we need to do is listen to an understanding voice, be ready to listen to that potential client's needs, carefully match them with a team member that will take them to the place that they need to be. So the initial consultation, when it comes to you, you want to start out as a conversation. Remember, the attorney-client relationship does not work unless the two of you, the client and the attorney, have trust in each other. That trust is built through rapport, listening. And listening first is what is the biggest important step to this. They've got a lot of issues on their mind, and it's better to let them vent for a little bit and build that rapport up, even if they're not in chronological order, even if they're talking a lot of different issues, those things. Just for 10 minutes at least, just listen to them without interruption. Let them talk about whatever the issue is. Take notes, show that you're actively involved in it, nod your head. If you're on the phone, give a lot of feedback, let them know. Continue on. Tell me what's next, but don't interrupt. Let them happen. It is permissible to bring back a friend if that doesn't breach the attorney-client relationship. You just have to identify that person as being an agent, or of course, if it's a corporation, an agent of the corporation. Now, after listening for the first 10 minutes, then you want to take back control. You can say things like, "I appreciate your thoughts. All that's more important, but I want to get some basic information for our file." Or, "Let me stop you right now. We're not going to get all the way through this. But let's talk about where and what you need to be looking at in terms of this case and what that consultation is going to be." You have to make the decision during this time period. Does this person need an attorney? And if so, is this something that we want to do? If you can get to that point, then you're going to be making a lot of the right decisions during this time. Custom fields is what we're wanting to fill out, just so we can generate that. And we want to give them things like a consent order. We want to give them an ebook of our civil litigation. These are all templates, and Clio will take you and guide you right through that. These are the things that we want to give them during this time. We want to give them the CEA. There's no flat fee in this, or family law, as my notes say here. Basic complaint of money owed. It doesn't have to have all the issues, just to show them what a complaint's going to look like. I want to show them a consent order, something that says like, okay, if you two of you, what do you want at the end of this? And we want to be able to put that into an order, even at the early stages, so they can see the end in mind. Any kind of discovery documents, because all these kind of information is going to be document rich environment. You're going to have a lot of different things you're going to be wanting to get. You're wanting to get as much of that information in as you can. And you want to give them the homework and information on how to do that and what they need to do next. Generate the documents and give it to them. And make sure that you do it by e-sign on the CEA. But you want to open up that client portal from the very beginning and show them that they have a lot of information that's going to be coming their way. Assume the sale and then talk to them about the service. And you want to do at least $2,500. In this slide, I talk a little bit about what that money and how to sell that. You want to, tell them that they're in the driver's seat. You want to talk about that this is something that our firm has done thousands of times before, that whatever service that we provide for them, it's going to be worth 10 times that amount, to get dad's will resolved finally. Even if we had to charge $50,000, it's worth $500,000 to you to have that done and have that resolved. And talk to them about family members, other people, and other ways that they could have these matters resolved. Sign them up immediately. Don't wait. Don't say, I'm going to go research it. We know it's civil litigation. You are not going to know the answer to the question. Do not IRAC this situation. You don't need to know all the issues, the rules, application, and tell them if they're going to win their case or not. All you have to say is, you clearly need to have an attorney. I need to research that. You need to go ahead and retain now. Let's move forward. And if you're in doubt on a civil litigation case, charge a $3,500 retainer. That's enough for us to get started. We can make a determination about where we're going to go. But if they see that, I think that will get you to the next steps. Do not do a demand letter for a low amount of money. Demand letter is not an area of law. You want to solve their problems. You want to get, but I needed to get them on board and then I could sell the services. You are not moving that case forward. I'm not saying don't do a demand letter. That may be step one of whatever the case is, but you want them to retain first and then be able to move forward. These are some of the additional fee structure issues for South Carolina litigation, definitely $5,000, just as more issues in South Carolina. Injunctions, $5,000, jurisdictional issues, $3,500. High value cases over $1 million, definitely go to $10,000 on that. And have each one of these additional structures, make sure that you've got that covered. Once that potential client leaves the office, you need to be constantly pursuing that person. You need to be pursuing them. You need to be able to get from where they are questioning about it. You need to be the one reaching out to them. Not as the attorney, you need to be involved in that. As a case manager, you need to be involved in that. You need to be constantly reaching out to get that process. So that is stage one of civil litigation. In just a moment, we can talk a little bit more about stage two, and the next process is once they're retained.